Welcome back to the deep dive. Today we are wading into some really murky waters.
Yeah, we definitely are.
Usually when we talk about crime, we picture the aftermath, the
Hmm.
broken safe, the stolen car, or the body on the floor. But today we are looking at our source materials to talk about the steps before the disaster, the planning, the asking, the trying.
Precisely. We are looking at inchoate crimes and the theory of accomplice liability. It is a fascinating area of law because it forces you to ask a really difficult question. At what point does a bad thought turn into a punishable crime?
Right. It is the law of almost and what if. And looking at the research you have pulled together for us today, this seems to be a battleground between two very different legal philosophies.
That is the key friction point. Throughout this discussion, we are going to see a constant tug of war between the common law, which is the traditional older set of rules, and the model penal code, or MPC.
And the MPC is the modern statutory approach, right?
Exactly. The common law generally waits until you are dangerously close to causing harm. But the MPC is much more aggressive. It wants to catch the dangerous person before they can even strike.
It is almost like a thought police approach. Okay, let us map this out for you listening at home. We have a timeline of a crime here. It starts with an idea, moves to an agreement, then an attempt, and sometimes involves helpers. Let us start at the very beginning, the idea, solicitation.
Right, so solicitation is essentially the crime of asking.
Give me the black letter rule. What actually constitutes this crime?
Like all crimes, we break it down into the mens rea, the mental state, and the actus reus, the physical act. For solicitation, the mens rea is purpose. You must specifically intend for the crime to be committed. You cannot accidentally or negligently solicit someone.
So if I jokingly say to my assistant, ugh, I would kill for a coffee right now, and they actually could go murder a barista.
You are not liable for solicitation. You lack the purpose that a crime be committed. It was just hyperbole.
Okay, good to know. And the act.
The actus reus is the asking itself. Asking, enticing, or urging another person to commit a crime. And here is the kicker. The crime is complete the moment the words leave your mouth. It does not matter if the other person says no.
Now, I saw a note in the source material about an uncommunicated offer. This feels like a law school exam nightmare. Let's say I write a letter offering you $5,000 to rob a bank. I put it in the mailbox, but it gets lost. You never see it. Did I solicit you?
This is where that philosophical split we mentioned kicks in. Under common law, the answer is generally no. If the communication does not reach the target, you have not technically solicited them. It might be an attempted solicitation, but not the full crime.
And under the model penal code.
The MPC is much stricter. Under the MPC, an uncommunicated offer is solicitation. The code focuses on your conduct and your intent. You wrote the letter. You mailed it. You are a dangerous person. The fact that the post office lost it is completely irrelevant to your guilt.
That is a huge difference. Okay, let us move the timeline forward. I ask you to rob the bank, and you say yes. You actually go and do it. I am obviously in trouble, but here's the question. Am I charged with the robbery and the solicitation? Does the asking count as a separate crime?
That brings us to the merger doctrine. In this case, the answer is yes, it merges. If the crime is actually completed, you generally cannot be convicted of both the solicitation and the completed crime. The solicitation fades away, and you become liable for the underlying crime, the robbery, as an accomplice.
That makes sense. You do not get double-dipped for the setup if the payoff actually happens. But let us look at the next step on the timeline. We have moved past asking, now we are agreeing. Conspiracy. How does this differ from solicitation?
Conspiracy is the darling of prosecutors. It really kicks things up a notch. The mens rea is still purpose. We have to want the crime to happen. The actus reus is the agreement itself. But importantly, most jurisdictions add a safety valve here. They require the agreement plus one overt act in furtherance of that agreement.
An overt act. Does that mean we have to be halfway through the bank robbery?
No, not at all. An overt act can be completely trivial. Buying a ski mask, renting a van, even drawing a map on a napkin. Just something in the physical world that shows the agreement is live and not just talk.
Okay, back to the merger doctrine. If we agree to rob the bank and we actually do it, does the conspiracy merge into the robbery like solicitation did?
This is a crucial distinction you need to remember. No merger. Conspiracy is unique. You can be convicted of the conspiracy and the underlying crime. It is a separate and distinct offense. The law believes that two people grouping up to plan crimes is a special kind of danger, so they punish the planning separately from the doing.
So conspiracy is stickier than solicitation. Now, let us talk about the scope of liability. This is the Pinkerton rule, right?
Mm.
Liability for other crimes committed by co-conspirators.
Correct. Liability for foreseeable crime.
So if I agree to rob a bank with you, and while you were inside, you panic and shoot the security guard, I did not agree to a shooting. I agreed to a robbery. I am just waiting in the getaway car. Am I on the hook for the shooting?
Yes, you are. The rule is that a conspirator is liable for other foreseeable crimes committed in furtherance of the conspiracy. If you conspire to commit a violent felony like bank robbery, a shooting is foreseeable, you own that crime too.
That is terrifying. It really incentivizes you to pick your partners carefully. Speaking of partners, let us look at the parties element. I love the undercover cop scenarios. Let us say I approach someone to start a drug ring. I am dead serious. They nod and agree, but secretly they are an undercover officer. They never intended to go through with it. Do we have a conspiracy?
This depends entirely on your jurisdiction. Under the common law, the rule is bilateral. It takes two to tango. Both parties must sincerely agree. Since the cop was faking, there is no meeting of the minds, so strictly speaking, there is no conspiracy.
And the MPC.
The MPC applies a unilateral approach. It looks at your mind. Did you agree? Yes. Did you intend to commit the crime? Yes. So under the MPC, you are guilty of conspiracy, even if the other person was faking it.
Once again, the MPC targets the dangerous individual, regardless of the result. Before we move to attempt, I want to introduce a visceral visual concept from the source notes. The wheel and chain conspiracies. Why do we need geometry to understand crime?
It is a way to map out the scope of the agreement. Imagine a chain conspiracy like a drug distribution line. The manufacturer sells to the smuggler sells to the dealer sells to the user. Everyone is a link in the chain. Because the manufacturer knows the dealer exists, even if they never met, they are all dependent on each other. They're usually considered one big conspiracy.
And the wheel.
Think of a hub and spokes. The hub is the central criminal, maybe a fence buying stolen goods. The spokes are the various thieves he buys from. The question is there a rim on the wheel connecting the spokes? Do the thieves know about each other? If not, you do not have one big conspiracy. You have a series of separate, smaller conspiracies. This matters massively for how many counts you get charged with.
Okay, moving down the timeline. We solicited, we conspired, now we are actually doing it. Attempt, the crime of trying. What are the elements?
Again, the mens rea is purpose. You have to intend to complete the specific crime. The actus reus is the tricky part. It requires more than just preparation.
How much more? What separates preparing from attempting?
We have two main standards. The common law tendency is the dangerously close test. You have to be right on the verge of completing the act. The MPC standard is the substantial step test. You have to take a step that strongly corroborates your criminal purpose, like lying in wait or scouting the location, but you do not have to be quite as close as the common law requires.
And for the record, does attempt merge?
Yes, it merges. You cannot be convicted of attempted murder and murder for the same killing. If you succeed, the attempt is absorbed.
All right, final pillar before we get to the defenses. Accomplice liability. You mentioned earlier, this is a theory of liability, not a separate crime.
Correct. You do not get charged with accomplice liability. You get charged with murder or robbery under a theory of accomplice liability.
So what defines a helper?
The mens rea is purpose regarding the underlying crime. You want it to succeed. The actus reus is providing aid or encouragement.
Can an accomplice be liable for things they did not explicitly plan?
Yes, just like conspiracy, they are liable for other foreseeable crimes.
Let us throw a complex, visceral application at you. The supplier of goods scenario. Say, I own a hardware store. A guy comes in and buys a crowbar, a ski mask, and a blowtorch. I have a pretty good feeling he is not fixing his plumbing. I sell it to him anyway. He robs a bank. Am I an accomplice?
This is difficult because of the mens rea. Remember, I said you need purpose. Here, you definitely have knowledge. You know he might use it for crime. But is your purpose to help him rob the bank? Or is your purpose just to make a sale?
I mean, I just want the $20 for the blowtorch.
Exactly. So generally, mere knowledge is not enough. However, the courts sometimes struggle with this. In serious cases, a court might infer intent from knowledge, especially if the goods have no legitimate use or the volume is suspiciously high, but it is a gray area.
Okay, we have built up all these ways to get in trouble. Now we need to cover the ways out. The defenses. The source outlines two major cases or doctrines for defense, withdrawal, and impossibility.
Correct. These are the heavy hitters for analysis.
We are going to do this methodically. I want to treat these strictly like case studies. I will tee up the concept, and I want you to walk us through the FIRAC structure, facts, issue, rule, analysis, conclusion. Let's analyze the case of withdrawal. First, what are the legally dispositive facts?
The facts usually involve a defendant who has already solicited, conspired, or aided in a crime, but before the crime is actually completed, they have a change of heart and try to back out.
And what was the core legal issue?
Is voluntary renunciation a valid defense to liability?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The rule has two distinct elements depending on the specific doctrine. Element 1 covers solicitation and conspiracy. Under common law, withdrawal is a defense to the future crime only, not the solicitation or conspiracy itself. Under the MPC, it is a defense if there is voluntary renunciation and the defendant thwarts the crime. Element 2 covers accomplice liability. Under both common law and the MPC, withdrawal is valid if one neutralizes the aid.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, the thwarting requirement?
To thwart means you must successfully stop the crime. The sub-issue is whether walking away is enough. The sub-rule is that you must actively prevent the result. Applying the facts, if I agree to rob a bank, then call you and say I am out, that is a mere change of heart. It is insufficient under the MPC for conspiracy or solicitation. I am still guilty. To satisfy the element, I have to call the police or physically stop you. The court concludes that the result matters.
Understood. Now what about the second element, neutralizing the aid requirement for accomplices?
Here, the sub-issue is what constitutes effective neutralization. The sub-rule requires the accomplice to wholly undo their assistance. Applying the facts, if you gave the principal a gun, you must get that gun back or call the police. You must effectively undo your contribution. If you just say, do not do it, but leave the gun there, the court concludes you have not neutralized your aid, and this element is not met.
And after analyzing all the elements, what was the court's final conclusion?
The court ultimately holds that withdrawal is rarely a defense to the inchoate crime itself under common law since the crime was already complete. But it is available under the MPC if the defendant successfully prevents the harm or completely neutralizes their aid.
Excellent. Now, let us do the second one. Let's analyze the case of impossibility. First, what are the legally dispositive facts?
Here, the defendant tries to commit a crime, but it cannot be completed due to external circumstances.
And what was the core legal issue?
Does the impossibility of the act absolve the defendant of attempt liability?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The rule breaks down into factual versus legal impossibility. Element 1 is factual impossibility. This is when the facts make it impossible, like a gun not being loaded. Element 2 is legal impossibility. This is when what the actor intends to do is not actually a crime, which is pure legal impossibility, or the legal circumstances prevent it.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, factual impossibility?
The sub-issue is whether a factual barrier negates intent. The sub-rule is that factual impossibility is no defense. Applying the facts, if you try to pick a pocket and the pocket is empty, you still intended to steal and took the act. The court concludes that the element of factual impossibility provides zero protection. You are guilty of attempt.
Understood. Now what about the second element, legal impossibility?
The sub-issue here is whether the law punishes the intent to break a non-existent law. The sub-rule splits. Under common law, yes, legal impossibility is a defense. Under the MPC, it is no defense because the MPC focuses on the actor's dangerousness and intent, not legal loopholes. The exception is pure legal impossibility. Applying the facts, if you think it is a crime to chew gum and you try to do it secretly, chewing gum is not a crime. The court concludes that pure legal impossibility is always a defense, but standard legal impossibility only protects you under common law.
And after analyzing all the elements, what was the court's final conclusion?
The court's holding synthesizes to this. If the impossibility is factual, you are guilty. If legal, you are guilty under the MPC, but might be acquitted under common law.
That is a crucial distinction. We are nearing the end of our dive. I want to pull all of this together. If you are listening and staring at a complex scenario, how do you attack it? Synthesize this into a framework for us.
Absolutely. Here is your step-by-step diagnostic checklist to synthesize all the rules from this module. Step 1. Identify the role. Is the defendant the principal or the helper? If they are the helper, go straight to accomplice liability. Check for purpose and aid. Check if they neutralize their aid for withdrawal.
Okay, what is step 2?
Step 2. Identify the stage. Did the crime actually happen? If no, look for encoded crimes.
Right, the preliminary stuff.
Step 3. Check solicitation. Did they ask? Note that this merges if the crime actually happens. Step 4. Check conspiracy. Did they agree? Look for an overt act. Check Wharton's rule.
What is Wharton's rule again?
That is the rule asking if the crime inherently requires two people, like dueling. If so, you need three people for a conspiracy. And remember, conspiracy has no merger. Step 5. Check attempt. Did they take a substantial step under the MPC or get dangerously close under common law? Check impossibility. Remember, factual is never a defense. Legal is only a defense in common law.
And the final step?
Step 6 is the final Polish. Check specific defenses like protected class. For example, a victim cannot be an accomplice. Or check for inevitably incident conduct. This checklist gives you a structured analysis for any problem.
That checklist is gold. It really highlights how the law tries to catch bad actors at every single stage. The ask, the agreement, the attempt, and the aid.
Exactly. It connects back to the bigger picture. We are not just punishing result, we are punishing the will to do harm.
It is not just about what you did, but what you wanted to do and how close you got to actually pulling it off.
The law punishes the mind, the purpose, and the step, the act or agreement, even if the tragic result never occurs.
It leaves you with a really provocative thought to mull over. If the law already punishes the mind and the step, what happens in the future when technology can literally read the mind before the step is even taken? Where does the law draw the line then?
That is a terrifying thought for another day.
Indeed it is. Well, we will close the file on Kuminate crimes for now. Thanks for diving in with us.
Always a pleasure.
Keep those checklists handy, and we will see you on the next deep dive.